SJC-12331, Public Employee Retirement Administration Commission v. Contributory Retirement Appeal Board and others.
Ms. Corrigan, we generally don't get this war of brothers here, Purack against Crab, so...
It is very rare, Mr. Chief Justice.
Okay, so we will try to resolve this civil war here. You may proceed.
Thank you, Mr. Chief Justice. Good morning, Your Honors. Judith Corrigan, Special Assistant Attorney General for the Public Employee Retirement Administration Commission. Your Honor, when a public employee, Your Honors, when a public employee takes vacation or sick time, that is part of their regular compensation. It is part of their salary, and it is included in their retirement calculation at the end of their career. This is true whether a public employee takes a week of vacation time, takes a week of sick time, takes a partial week or a partial day. And it should not be any different if a public employee is having workers' compensation paid to them alongside that payment. That should not change the payment from its regular compensation status. This is, if Mr. Venava had been injured on the weekend and had been out for an extended period of time, there is no dispute that if he was on sick time under the Family Medical Leave Act or other acts, he would be receiving regular compensation. If he had a minor injury over the weekend and had to take a half a day, the sick time he took would be regular compensation. Under this decision, CRAB is saying that when an employee has workers' comp, the character of the regular compensation that is paid changes. CRAB is also introducing into our retirement law something that we haven't seen before, which is that vacation time and sick time will be excised from regular compensation in these circumstances because no services are being performed for the employer.
But we're not speaking, again, this is not an area of my expertise, so excuse ignorance, but this is not a question of how you would calculate the amount of salary from which you determine retirement amount, correct?
This is not, you're correct, Mr. Chief Justice. This is not a traditional case that we're all familiar with, a superannuation retirement under Section 5, where you would take the 3 years of the 3 highest years and annual and mix them together and come up with the years and the...
Can you articulate what's at stake in a simple way for us?
What's at stake? Mm-hmm. You need to have a public employee retirement system which is uniform and treats everyone the same. And if you excise these regular compensation payments, there's no way to do it under the statute. CRAB has exceeded its authority in doing it, but you're going to be treating different people differently. So the first thing PERAC would say is that you cannot treat employees, public employees, differently, receiving the same sick and vacation time which they have already earned. And it may, in some cases, it may benefit the employee. It may cause him to have a larger retirement allowance. In some cases, it may be to the employee's detriment. He may get a lower retirement allowance. But in all cases, we need to have a rule. And PERAC asserts that the rule needs to be that when you receive regular compensation, regardless of whether you receive it in conjunction with workers' compensation, it needs to be included. And I think the danger of the CRAB way is made manifest in the McLaughlin case.
Before you get to that point, could you explain to me how this rule, as interpreted by CRAB, would benefit people, raise their retirement?
It could, for example, in this case, Mr. Vernava's retirement allowance is lower under the Swampscott Retirement Board way. The benefit to him is to get 11 months of 11 months back pay, and we'd all like to get 11 months of back pay. However, eventually, it will all come out in the wash, and Mr. Vernava will end up being paid less from the Swampscott Retirement Board. Also, he is subject to a workers' compensation offset. So it's very difficult to see, even in this case, even though Crabb says in its decision, not everybody will benefit, as the person does here. It's very difficult to see how he's benefited at all, since 14.2 requires an offset of the pension portion of his retirement allowance when he receives his back pay. And so sometimes if you have a later retirement date, you're going to have a higher salary, Your Honor, if that's the from which to base it on. So unlike the traditional superannuation retirement, the rate of pay for an accidental disability retirement allowance is sort of a snapshot, a 12-month snapshot of when you last received regular compensation, 12 months prior to receiving regular compensation, or the date of the injury, whichever is greater. It's usually not going to be the date of the injury because the injury would have been a long time. These things take time to make their way through the through the disability process. So if you have a later date, your salary that you're basing it on will be higher, as was the case in PERAC's calculation of Mr. Vanava's retirement allowance. So PERAC's calculation is based on a higher salary. He travels back 11 months to get his new back pay, and his salary is a little lower, and so his pension is lower. And the math, from a math point of view, it will all even out in 7 years if you uphold Crabb's decision, and Swampscott would actually be paying out less to him. And he's pretty young, he could live a long time, so this could be a meaningful amount of money.
Okay, counsel, what if the vacation and sick time that was paid out weekly was instead given as a lump sum for the same purpose? Would that, even if, or they paid directly to the union a big lump sum to pay for his fee and a big lump sum to the insurance company, would that change anything in the analysis?
Justice, that's always excluded from regular compensation, this lump sum payment. And we meant, and it should be distinguished. There's a difference between receiving vacation and sick time in lieu of actually taking sick and vacation time. And the exclusion in the statute and in PERAC regulations at 840 CMR 1503F is for a one-time lump sum payment of unused sick and vacation time. So that's always been excluded. For example, say Mr. Vernava had gone through his career and he had a lot of vacation time saved up at the end. He would get a lump sum payment, but that would not be pensionable. That would be excluded under the regulations and under the statutes. So so Crabb is introducing this idea that you have to be performing services in order to have vacation or sick time count as regular compensation.
Well, but they're not suggesting that you would do that for the calculation of wages with regard to superannuation. They're not saying that they're going to change their formula in determining what the 75% would come from.
They are limiting it to the receipt of payments with workers' comp.
Right.
What PERAC is suggested is that there's no basis in the law for so limiting it. What they say in Gendron, what they say in McLaughlin, what they say in this case is the employee performed no services, and in fact could perform no services. So this is one of the reasons it will be excluded from regular compensation.
I get that, but I mean, what's surprising about your argument is that if you are right, the employee can determine, well, am I better off if I don't take 2 hours of vacation pay and sick pay to pay life insurance and union dues, or am I better off if I do? So you could arguably hire somebody who will tell me, this is Mr. Vernava, this is what you should do. You should not take those 2 hours because you're better off with the earlier retirement date, or you're better off with it and therefore take 2 hours and get the later retirement date. Why does it make sense to let an employee do that by deciding whether he's going to take 2 hours of sick leave a week?
Well, an employee does decide when they take a regular vacation or when they take sick time, whether they'll take it or not. But the reason that, what PERAC is saying is that it doesn't lose its character as regular compensation. CRAB is going.
I take that point, but you're not answering my question. Is that, under your theory, it's not really gaming the system, it's somebody basically making an intelligent calculation. I'm better off by doing this or not. And
Yes.
therefore, I can make a determination which will affect how much I get in accidental disability coverage based on the little question of whether or not I take 2 hours a week, or maybe 1 hour a week by your
Maybe
theory, or
more.
even a half hour a week. So why should we let the employee do that?
Well, this is the way that, I don't think it puts much power into the employee. This is the way that this calculation has been made for decades. And this would be a gigantic change in the way retirement systems would be calculating retirement allowances. In fact, CRAB recognizes that in their decision on reconsideration, that there will be many retirement allowances that have to be changed. Swampscott recognizes that in its first letter to PARAC, where it says, please, PARAC, send a notice to the boards about this Gendron case. What's interesting about the Gendron case is that CRAB decided it sort of on equitable considerations. If you look at that decision, CRAB said this is a beneficent system. Chapter 32 is a beneficent system. And we are constrained to decide a case for the employee if, if it's going to benefit him, we have to decide it his way, which is not how the public pension system works. And to your point, there has to be a rule about this. There has to be a rule about, Mr. Gendron came in and asked for whatever it is his back pay was, and now Mr. Vernava wants his back pay. This isn't really benefiting Vernava. So I think it's better, PARAC thinks it's better to have a rule.
But how about this scenario when you're deciding which rule? So somebody's 57 years old, and they're out on workers' comp, and assuming that it's legitimate, completely legitimate, they say they're group 4, and they're doing 3 hours a week, and they're holding on until they're at that age where all of a sudden they're 61 or 62 or whatever age it might be, and now they've got a pension at a much, much, much higher level in a very short amount of time. I mean, when you say it comes out in the wash, it doesn't come out in the wash in that situation. That's a huge, huge difference in the amount of money for the Commonwealth.
Well, in this hypothetical, a group 4 person, police or fire, would not be covered by the workers' compensation statute. They'd be covered by Chapter 41, Section 111F. And in that statute, you get your entire pension tax-free until you retire, until you go off on retirement.
Forget the group 4.
Okay.
Point well taken.
Yeah.
But you see, my point is that you can sort of just use a little bit of sick time to get to the magic number, and that's got huge implications.
Well, the employee is not going to be able to manipulate the system. I mean, people will terminate an employee who can no longer perform their job. People need the spaces in the public employee system. So I believe that you're not going to keep an employee on workers' comp for the employee might be on workers' comp forever, but you're not going to keep him on the payroll forever. This is a thing with a limited shelf life. Mr. Vernava applied for accidental disability retirement. The statute gives a time frame under which that must be done. And when he retired for accidental disability retirement, he was still receiving regular compensation. So that did make his pension $3,700 more per year than it would be under the calculation to get the back pay, of which he's not going to get any back pay. So I see what you're saying, Your Honor, that somebody could try to manipulate things to stay on and get a higher salary, but I think most of these things play out in a very relatively short shelf life. You can't say, I'm going to take 2 hours of sick and vacation time for the next 10 years, employer. The employer is going to be racing you out the door. So, I would also point out that the legislature did put in Section 7.2 the receipt of regular compensation as one of the dates upon which an accidental disability retirement allowance could be set. And I think they did that because they understood that a person could receive regular compensation after they are no longer able to perform their duties after they have applied for accidental disability retirement. I mean, I guess one of the most disturbing things for us is the issue in McLaughlin, where it says that a person has applied for this, so they can't take their vacation and sick time anymore. And that, again, is in the unique situation of a corrections officer with their assault pay and their workers' compensation. But I would just point out there's only one exclusion in the law about vacation and sick time. There is no other qualifications put on this, and if there are no further questions, that will conclude my remarks.
All right, thank you.
Thank you.
Mr. Sacco, good morning.
Good morning. Excuse me, Mr. Chief Justice. Michael Sacco here on behalf of the Swampscott Retirement Board, as well as co-appellees Robert Vernava and the Contributory Retirement Appeal Board. I think to the court's point, to bring uniformity, predictability, and consistency to the application of the statute is to adopt Crabb's decision. Very simply, when an individual is hired for employment, focusing purely on the public sector, there's a contract made, either a personal services contract or a collective bargaining agreement that says, you employee will show up to work every day. I, employer, will pay you $50,000 for that year to do that. In addition, there may be some sick time, some vacation time, personal time, bereavement time, but within the context of that 1 year, you're only going to receive $50,000. Now, during that year, you can either show up to work as we've contracted, or through that contract, you can utilize a vacation day or vacation days or sick days or bereavement days. The distinction here, as Crabb relied on Zaleski, is that once an employee has availed himself of the workers' compensation statute, the employer is no longer obligated to pay that employee. That contract, that employment contract, in essence, is no longer, it may be still in effect in the sense that the person is still an employee, but that individual is now being compensated under the workers' compensation statute.
But isn't the time that they earn, don't they earn that time of the vacation and the sick over that period of time that they're working, right?
They do.
So
they do.
it's been accumulated and now it's being paid out. Doesn't it matter that it was already earned?
I don't think it does, Your Honor. It's certainly the employee, and we're not suggesting, and Crabb is not suggesting, that the employee doesn't have the right to utilize that time. The workers' compensation statute makes that clear. The question is whether it's regular compensation. Not necessarily that it's earned or when it was earned, but is it regular compensation? And there are many forms of wages or compensation that are not regular compensation. For example, the wage statute, which has been brought up, includes vacation pay and holiday pay as wages that must be paid. However, holiday pay is excluded from the definition of regular compensation except for public safety people. So there's not a direct marriage or symbiosis between the two, that if something is a wage, if it's on your W-2 and you have to claim it for tax purposes, that it's regular compensation. So what I think the import of Zaleski, which primarily the Crabb relied upon, the appeals court case, was not so much that it was the assault pay was not regular compensation, which I agree that it was not. It was that while the individual was being compensated under the workers' compensation statute, as a matter of law, there's been a determination that that person is no longer able to provide services to the employer. And that's where I think we get to what I'm assuming or speculating is the reason why the court took this case. The definition of regular compensation was amended effective July 1, 2009, and this is actually the first appellate case in which the court is being asked to define what exactly it means. That the definition was changed to base salary and other base compensation, and then there's a whole host of exclusions to the definition of regular compensation. But there's also a catch-all phrase at the end of that definition that talks about services, and I think that is the primary focus here. What this court and the appeals court has consistently said, prior to July 1 of 2009 and interpreting the statute was to be regular compensation, it had to be regular, recurrent, ordinary, not an ad hoc type payment. That was what this court applied from the Boston administrator's case back in 1980 through the Polonzi case in 2007, I believe it was. There's nothing regular or recurrent about sporadically using vacation time or sick time in this particular manner. And it is about the manner of the payment, not necessarily the character of the payment.
So do you, what's your position then on, had this been charged in a lump sum form of some sort and a big payment made to the union and a big payment made to the insurance, would that change anything for you?
It would not. I agree with my sister that the statute is clear. It says a one-time lump sum payment of vacation is specifically excluded. With that,
Regardless of what it's used for.
irrespective of what it's used for. And I think that was put in there, again, with the legislative intent to not allow artificial inflation of retirement allowances, because people will generally collect their, save up their vacation time to have a large payout at the end of the year. Some of them will go on vacation the last 4 weeks before they retire and use their vacation in that way. When vacation is used in the ordinary course, like sick leave or bereavement, it is regular compensation because you're still performing that contract with your employer. You're providing services. Granted, you're not providing a service while you're on vacation, but the employer has said, by agreement, we're going to allow you to not come to work, we'll still pay you. And that's all it is. It's
Really the nature of the payment. Now, see if I have this right. So that, say somebody's a long-time employee, they've got a lot of sick time. There's no workers' comp issue. And unfortunately, they have some serious illness, and they aren't working for a year. Maybe they use a sick bank. It's even longer than that. There's absolutely no problem with that being part of the contract and being considered for retirement. But here, it's the nature of the use of the sick leave, that's sort of the manner in which it's being used, a couple hours a week here and then a couple of hours a week there, that's the problem.
correct, Your Honor. And the sick leave example, the sick bank is an excellent example where the employer and the employee, again, have agreed that you're allowed to accrue sick leave, you're allowed to carry it over, you're allowed to use it in the sick bank, perhaps with the expectation that at some point you will be coming back to work. The employer also has the right, generally, may be limited in a collective bargaining circumstance where you may have to go through a process, but where an employee is no longer able to perform the essential duties, the employer can terminate. I disagree with my sister. Most employers will not do that. They won't run the risk of being the subject of a lawsuit under the disability statute for terminating a disabled employee. But the parade of horribles that my sister is painting in terms of what the narrowness of this decision actually would mean, I think is incorrect. Certainly no one is suggesting, Crab's not suggesting, that in any other context, when used in the ordinary course, that vacation leave would not be regular compensation. It purely just is not in this circumstance. And I would suggest that, for example, if a contract allowed an individual who didn't use his sick leave, but then cashed it in while he's still working, they said, okay, you didn't take vacation this year, we're gonna let you cash in so many days. I would suggest that's not regular compensation either, because you're being compensated for a position for a year with a particular salary. You can either show up and perform those duties, or you can utilize one of the many ways that the employer has agreed that you can take that day off. When someone is receiving workers' compensation, that changes the dynamic. That individual is unable to go back to work, is unable to work. And in this particular case, I think Justice Seifer was asking, what's the implications here? For Mr. Vernava, he wanted to go retroactive back. The statute sets forth 3 specific dates for the effectiveness of an accidental disability. It's the date of injury, the date that one last received regular compensation, or 6 months prior to the filing of the application, whichever occurs last. So if you agree with PERAC, because Mr. Vernava, As CRAB had written in its decision, and as we suggested in our brief to them, if you want to give the employee the Hobson's choice, do I take those sick leave days or those vacation days as a supplement so that I can maintain my health insurance and pay my union dues, or do I not take them and I give up going back to get the retroactive retirement date? And I again disagree with my sister. There is a benefit to that. There's a dollar for dollar offset in the retroactivity aspect of a workers' comp and an accidental disability, but accidental disability is a higher benefit than workers' comp. So while there is a dollar for dollar offset, there is a benefit to going retroactive. It's 66% versus 72%. It may be a small amount, but there is a benefit to going back retroactive for Mr. Vernava. But to Chief Justice Gantz's point, this shouldn't be a decision that an injured employee has to make, hopefully with the advice of learned counsel. CRAB has set a standard that is very easily administrated and very easily understood by adopting its position and not considering these type of supplemental payments. With respect to the fact that PERAC has given this advice over many years and its predecessor did, well, I mentioned earlier the Polonzi case. That was in 2007, a case that I actually argued here, again, with respect to a PERAC opinion that this court deemed the personal use value of a motor vehicle was not regular compensation. Following that decision, every retirement board in this Commonwealth that had provided that benefit erroneously was required to go back and correct it. And the statute specifically requires us to correct errors when errors have been made. So while there could be some administrative problems with administering such a decision because of the way that it has been misinterpreted in the past, that's not a reason to not correctly apply the statute today and prospectively so that there can be uniformity to this, and that Mr. Vernava, in this particular example, can receive his workers' compensation, utilize his accrued vacation time to pay off those other expenses and benefits, but still be able to secure the retirement date and the retroactivity that's guaranteed to him under the statute. This seems to unnecessarily penalize him and put him in that position of making a Hobson's choice. Lastly, I just want to, Chief Justice Gantz, I think somewhat half-jokingly talked at the outset about the CRAB and PERAC dynamic here. Again, back to Polonzi, this is the second time I'm aware that this issue has come about where CRAB and PERAC have been before you asking for you to essentially make a determination between the hierarchy of administrative agencies, if you will, in deciding the statute. I think as the court said in Polonzi correctly, and as the court has consistently said, when there's a question of law that is before you de novo, however, the case law is also clear, and it says that when a CRAB decision is reasonable, it should not be disturbed. So I think 2 points on that. One, I think this CRAB decision is eminently reasonable in terms of an interpretation of the statute, and it should be upheld. But secondarily, to the extent that the court is willing to resolve this issue of what takes precedent, CRAB or PERAC, I think it would be helpful for those of us in the retirement community where we are being asked as retirement boards to interpret the statute and apply it appropriately in the absence of any clear regulation or authority from the court. We try to do that, obviously, consistent with the statute and the rulings of the court, but it would certainly be helpful for the court to determine who takes precedent. Who do we as retirement boards, I speak now as Swampscott, not for CRAB, who do we listen to? We understand there are certain circumstances where PERAC must approve an action of a retirement board, and we understand we're bound by that, and we have a right to appeal that. But there are CRAB decisions, as PERAC points out in its brief, that, and it's true, that only an administrative decision is binding only on the parties. So if PERAC's not a party, it's not bound. But there are also circumstances where PERAC agrees with the decision of CRAB that it's not bound, and it's telling us we have to follow the decision even though we're not a party to it. So it would be quite helpful for us if the court could kind of lay out the landscape, and, if you will, as to how we as retirement boards should proceed in that manner. Unless there are other questions, I don't have any other further things to say to the court.
All right, thank you.
Thank you very much.